Several federal bills have recently been introduced in Congress that include restrictions on abortion access. Legally speaking, this could have a major impact on Ohio law, specifically the Reproductive Freedom Amendment, which passed with 57% of the vote in November 2023. It guarantees abortion access in Ohio up to the point that a fetus is able to survive outside of the womb to be determined by a doctor on a case-by-case basis. That's typically up to about 22 weeks after conception. According to the American Civil Liberties Union, if these newly introduced federal bills pass, it would make it harder, if not impossible, for a woman to get an abortion if she needs one. Now, in general, under the U.S. Constitution, a federal law overrides state constitutional law. So if federal bills restricting abortion access become law, that means the state constitutional amendment guaranteeing access to abortion in Ohio could be restricted or even go away entirely. Case Western Reserve University School of Law professor Jonathan Enton explains it like this. The question would be whether a federal abortion statute is constitutional. The issue would be whether the federal government has the power to act. Supporters of these bills would probably rely on the Commerce Clause, which the Supreme Court has interpreted pretty broadly to allow Congress to pass laws that regulate persons or things that are in or affect interstate commerce. Any bill introduced would have to pass in both houses and be signed by the president to become law. If a bill restricting abortion at the federal level becomes law, states with less restrictive laws of their own would likely challenge it, and it would likely end up in front of the U.S. Supreme Court. This is Stephanie Haney, Legally Speaking, for 3 News.